Good morning, this is your Kelso Report for Tuesday, February 12th, and I'm your host, Clark Kelso. We begin today with a case raising the question of whether a police officer loses his qualified immunity when his otherwise lawful arrest of a suspect was actually motivated by his desire to retaliate against the suspect for the exercise of First Amendment rights. We continue then with the First Amendment in a case involving a municipal sign ordinance, and then we turn to a state law decision on the question of whether in-home support service workers are county employees for purposes of federal and state labor and wage laws. Let's first turn to the Ninth Circuit. It is, as we've pointed out frequently before, it is very difficult to successfully sue a government employee for damages for an alleged violation of rights. There is this little matter of sovereign immunity and qualified immunity that protects government officers from liability. Pursuant to the doctrine of qualified immunity, the plaintiff must show that first, the facts viewed in the light most favorable to the injured party show that the officer violated a constitutional right, and second, that the right was clearly established at the time of the alleged violation. The plaintiff in Ford v. City of Yakima alleged facts that, according to the Ninth Circuit majority, would establish a violation of the plaintiff's clearly established First Amendment right to be free from police action motivated by retaliatory animus, even though probable cause also existed for the police action. In particular, a routine traffic stop took a turn for the worse when the plaintiff initially presented an aggressive attitude towards the police officer, getting out of his car and asking, "Why are you stopping me?" Although the plaintiff returned to his car when instructed by the officer had already decided to at least arrest him for a noise ordinance violation. His radio was pretty loud, and indicated to another officer that he would either give the plaintiff a ticket or take him to jail, depending on the plaintiff's reaction. Well, he ultimately arrested the plaintiff, and then an argument broke out where the plaintiff accused the officer of making a racially discriminatory stop and arrest, and the officer said, among other things, "Stop running your mouth and listen. If you talk over me, you are going to jail, sir. Do not talk over me. If you cooperate, I may let you go with a ticket today. If you run your mouth, I will book you in jail for it. Yes, I will, and I will tow your car. If you cooperate and shut your mouth, I'll give you a ticket and you can go." Well, you get the picture. That was enough for the Ninth Circuit to declare that the officer lost his qualified immunity. There was a dissent here. The dissenting judge thought the alleged right was not sufficiently well defined back in 2007 when the arrest took place, particularly since the suspect had already been placed under arrest when the police officer directed him to be quiet, and according to the dissent, the suspect already had lost some of his First Amendment privileges. Well, we have another First Amendment case from the Ninth Circuit, this one involving a municipal sign ordinance. Now, as a generality, regulation of non-commercial speech on the basis of its content is likely to be unconstitutional. Content-based discriminations usually trigger strict scrutiny, which is, of course, usually fatal. However, a 2-to-1 majority in Reed v. Town of Gilbert upheld a local sign ordinance that appeared to distinguish between types of non-commercial speech on the basis of content. The ordinance in this case regulated the size of temporary signs that gave directions to events, and it limited how long such signs could be posted. In particular, under the ordinance, plaintiffs' temporary directional signs may not exceed 6 square feet in size and may not be displayed more than 12 hours before or after the relevant event. In this case, the relevant event was Sunday morning church services. In contrast, political signs, defined as a temporary sign which supports candidates for office, may be up to 32 square feet in size and may be displayed any time prior to an election and removed within 10 days after the election. And ideological signs, defined as a sign communicating a message or ideas for non-commercial purposes, that are not construction, directional, political, or garage signs, may be up to 20 square feet in size and are not subject to any durational limits at all. So they clearly have different rules for different types of signs. Well, the majority held that these subject matter or type distinctions were not content-based in the constitutionally relevant sense. And the majority upheld the ordinance because it served a significant governmental interest and was narrowly tailored to serve those interests. The dissent, on the other hand, saw the ordinance as favoring certain types of speech based solely on its content, thereby triggering strict scrutiny, which the ordinance did not survive. My guess is that this case may interest the Supreme Court, since its facts really will help define the border between content-based and non-content-based, but still subject matter-based regulations of speech. A very nice area for the court to explore and define a little bit more clearly. Finally today, a case under the federal and state labor wage laws. This is a big win for the tens of thousands of individuals who provide in-home support services. The First District in Guerrero v. Superior Court has agreed with a prior Ninth Circuit decision that under California's extremely complex system for providing in-home support services to individuals who cannot fully care for themselves, providers of in-home support services are employees of the counties, which under state law are required to somehow provide in-home support services. They can do it in 5 or 6 different ways. But under this case, under this holding, the providers are considered to be employees of the county. The court reasoned that under the statutes, the counties exercise considerable control over the nature and structure of the employment relationship. The counties get to choose how that gets structured. And the county exercises complete economic control over the relationship, how much people get paid. The economic reality is that the counties and their agencies employed the workers to perform social services for the benefit of the recipients. Now the decision is important because, among other things, it now makes the counties responsible for ensuring that the providers get paid, even though in many counties the county has by contract tried to delegate that responsibility to a private sector entity. While the county may delegate the mechanics of making payments, under the court's holding, the county retains legal accountability for making sure the payments are actually made. And that's it for today's Kelso Report. Have a great day in the law.